Hi, I'm Gidon and I'm a lawyer in the Litigation and Dispute Resolution Group here at McCabe Curwood. The close of the 2019 law term is only days away, and 2019 has been another year of intriguing decisions handed down by the Australian High Court. I'll be discussing two High Court decisions of particular interest, and my colleague, Nathan Jones, will separately discuss some other interesting High Court decisions. The decision of Comcare and Banerji was one that grabbed the attention of the broader public. In this case, the High Court considered whether the provisions of the Public Services Act on terminating a public servant's employment, Ms. Banerji, constituted a contravention of the implied freedom of political communication in the Australian Constitution. For those who aren't aware, the implied freedom of political communication is a limitation on the power of the legislature when exercising its functions to curb political communication. Ms. Banerji was an employee for the former Department of Home Affairs and therefore subjected to the obligations under the Public Service Act. While employed, she operated a Twitter account that made over 9,000 tweets, a number of which criticised the department and its policies. Ms. Banerji operated under the cloak of anonymity. One could not identify the Twitter page belonging to Ms. Banerji or to an employee of the department. Following an internal investigation, her identity was discovered. It was ruled that she had breached the Public Service Act and her employment was ultimately terminated. The relevant sections of the Act included Section 1311, which required Australian public service employees to uphold the APS values, integrity and good reputation of the APS. Section 10.1, which sets out the APS values, including an apolitical, impartial and professional Australian public service. And Section 15.1, which provides for sanctions, including termination of employment for breach of the code. Eventually, Ms. Banerji approached the Administrative Appeals Tribunal, which referred to the High Court the question on whether her termination contravened the implied freedom. The High Court allowed the appeal. Ms. Banerji argued that the provisions could not extend to anonymous communications. However, the High Court rejected this argument and noted that as a rule of thumb, anyone who posts anonymously may have their identity revealed at some point. And in any event, had she remained anonymous, the damage would still have likely occurred. Further, the court found, amongst other things, that sure, Section 1311 stifles political communication of public servants, but it rejected that the burden was an unjustifiable one. Rather, the provisions are for a legitimate purpose, as it preserves the values, integrity and good reputation of the APS, in being an apolitical and professional service, all central to ensuring responsible government as mandated by the Constitution. The court also found that the laws are suitable and necessary. And finally, it was held that the law is adequate and balanced for reasons including the provision of procedural fairness under the Act. The second case I'll talk to is the case of Connective Services Proprietary Limited and Sleep Proprietary Limited. In this case, the High Court ruled that the connective companies contravened Section 261 of the Corporations Act by taking out legal proceedings to enforce a preemptive rights provision. Put broadly, preemptive rights provisions require a shareholder to first offer its shares to other existing shareholders prior to being offered to any third party. Section 26A(1) allows for a company to financially assist a person or company to acquire shares only if the assistance does not materially prejudice the interests of the company or its shareholders or the company's ability to pay its creditors. So in this case, SLE was one of the three shareholders in the appellant connective companies. SLE had a falling out with the two other shareholders and had stopped taking an active role in the business. SLE then entered into an agreement to transfer its shares to a third party, notwithstanding that the constitution of the connective companies contained a priority rights provision. In 2016, the connected companies commenced proceedings, seeking to compel SLE to offer its shares to the other shareholders. In response, SLE sought an injunction under Section 1324 of the Corporations Act to restrain the connective companies from pursuing litigation as it contravened Section 261 of the Corporations Act. The High Court agreed with SLE. It was ruled that commencing legal proceedings did constitute financial assistance. Here the court gave the term broad meaning. Taking out legal proceedings meant that the other two shareholders' cost exposure had been relieved. The court acknowledged that no evidence was presented to explain whether the company had sought funding or an indemnity from any cost liability from the other two shareholders. It was also held that SLE had suffered material prejudice. The court adopted a low threshold for the meaning of material prejudice. The two shareholders were aware of the financial significance of the legal proceedings, having received a cost estimate and being aware of the possibility of an adverse cost order. Consequently, SLE would be materially prejudiced as its net equity would be reduced by such costs. So to hear more about some interesting decisions handed down by the High Court in 2019, please go check out the recent video blog by my colleague Nathan Jones. Thank you.